Remember Bill Wurtz's History of Japan video, particularly about how in the year 604, the new prince heard of this rad new religion from Viecht, and asked everyone to try it out, but they said no, so he asked again, but they said no again, so the new religion was adopted with all the rules that it entailed? Those rules are known as the 17 Laws. Don't confuse this with FIFA's 17 Laws of Football, also known as soccer to Americans. The 17 laws instituted by the prince were more like a cross between a constitution and a Buddhist version of the Ten Commandments, as opposed to something that one would expect to see in a modern legal code. Like many other aspects of early Japanese society, such as the writing system, Japan's criminal justice system was based on China's. Japan's first recorded criminal laws were created in the early 8th century under the Taika reforms. As described by Bill Wurtz, these reforms made Japan's government govern more like China, which is a government that governed more. As shown by these new laws, Japan followed the Confucian ideal where authorities and officials serve as models for people's behavior, and people were obligated to follow the moral norms set by them. Criminal justice in feudal Japan was a harsh and grotesque reality. The following were the main hallmarks of this system. Social class favoritism. The samurai, which were the ruling class, enjoyed lenient treatment in comparison to the rest of the non-ruling population. Torture was standard, but to be fair, torture was also common for a few centuries in medieval Europe. Collective guilt and guilt by association. In contrast to modern countries, which only allow personal guilt for a crime, feudal Japan punished people just because they were associated with or related to an offender. For instance, if you are a peasant and got caught shoplifting, you and your friends and family could be put to death. Finally, cruel and unusual punishments. Judges in daimyo and shogunate courts had great discretion in deciding punishments for offenders. The death penalty was commonplace and was dished out in many shapes and forms. Select a punishment for the defendant. As for the administration of criminal justice in feudal Japan, it was primarily vested in the many daimyos that each had their own fiefdoms throughout the country. As a result, the daimyos, the Japanese equivalent of feudal European lords, exercised most of the authority when it came to dealing with crime. On the other hand, the shogunate created a court of justice, and this court was strengthened when the Supreme Council was formed to further the shogun's power over the daimyos. This system did not change much throughout the tumultuous Warring States period, the Sengoku Jidai. There were some moves toward uniformity after Tokugawa Ieyasu maneuvered his way into control of the shogunate and all of Japan. Many of the existing rules and punishments were codified in the 1700s, with limited success. Overall, if you were not a samurai, criminal justice in feudal Japan was an especially unfair and brutal affair. As with many other aspects of Japanese society and technology, the criminal justice system did not fundamentally change during the 2 centuries of Japan's isolation from the outside world. Eventually, Japan would be metaphorically turned upside down as the powers exerted by the outside world started to envelop the island. The turning point was when the United States gently knocked on Japan's door and declared, "You can do this the hard way or the easy way. The easy way is to submit. The hard way is to submit." Japan's leadership had no choice. The Western world had grown and developed by leaps and bounds, while Japan stagnated under its insular policy. The Age of Enlightenment, with its explosion of ideas, revolutions, and Napoleonic exploits, brought sweeping changes to much of Europe, including in criminal justice. Of course, Europe was not the only place ahead of Japan in criminal justice. The United States was boasting its new constitution and approach to fair trials. The great powers of the West saw Japan's feudal justice system and said, "Wow, you guys are barbaric. And you know what that means? We can boss you around however we want." Japan went, "Oh crap," and realized it had been thrust into an adapt or die situation. If Japan wanted to not succumb to the boot heel of the West, it had to do catch up in record time, transforming a feudal society with an entrenched ruling class of traditional samurai into a modern industrial society with new leadership and a standing conscript army. Thus, the Meiji Restoration ensued. Japan opened itself up to a flurry of Western concepts and ideals. Among them was criminal law and procedure. Japan created its first modernized criminal justice codes with the Penal Code and Code of Criminal Instruction in 1880. These were based off of France's Napoleonic Code. However, this new French-style criminal code was not the neatest fit for Japanese society, and was further encumbered from being complicated and difficult to understand, especially the procedure for serious felonies. As the German Empire ascended to prominence in the late 1800s and forged its own colonial empire, German legal influence seeped into Japan. The Meiji Constitution emulated Germany's constitution, and criminal law would also follow Germany's example. First came a new criminal procedure code in 1890, followed by the creation of a new penal code in 1907, which is still used today. A newer criminal procedure code was introduced in 1922. Between the French and German styles of criminal justice, sweeping changes transformed feudal Japanese justice into a more modern criminal justice system. Some highlights were the abolition of social class bias. All defendants were now treated equally. The abolition of torture. The abolition of collective guilt and guilt by association in favor of personal guilt only, and the restriction of the death penalty to hanging, which is still effective today. Along with these major reforms and rapid advancements in other areas, Japan had arrived on the world stage and set out to carve its own empire. Its big debut announcement was the Russo-Japanese War, where Japan surprised the world by inflicting a crushing defeat against the Russians. Around this time, the new criminal justice system was established, and would remain mostly unchanged while Japan's power and influence grew in the Far East. In 1928, Japan implemented a jury system for some criminal trials. A considerable drawback to this system was that defendants had to forfeit their right to appeal if they chose this option. Although this system yielded lower conviction rates, it was eventually phased out in 1943 at the height of World War II. After all, why waste time and resources throwing people into jury boxes when you could be throwing them against American soldiers? A jury system of any kind would not make a return until recent years. After Japan's devastating defeat in World War II, it was subject to Allied occupation. Japan's constitution was massively revised to restrain the emperor's power to a mostly ceremonial role, which still holds true today. The law was also revised to incorporate many of the fundamental rights that Americans enjoy. As for criminal justice, the Penal Code of 1907 was mostly unscathed. On the other hand, the laws governing criminal investigation and procedure were overhauled with American rules that better respect defendants' rights. However, what ensued in Japan's criminal justice system was an amalgamation of European and American law coupled with Japanese culture. Although there have been some changes and reforms in recent years, the laws and rules governing Japan's criminal justice system have mostly stayed the same since the reforms imposed by the United States. Let's cover what major elements of Japanese criminal law are similar to American criminal law. The prosecution must disclose its case and evidence to the defense. In Japan, this is typically addressed at a pretrial conference. In the United States, this kind of pretrial conference is included in the discovery process. Prosecutors have discretion in choosing what cases to prosecute. The prosecution must prove the defendant guilty beyond a reasonable doubt. The defendant legally has a presumption of innocence. And constitutional rights, many of which were imported from the US Constitution's Bill of Rights, like protections from unlawful searches and seizures, cruel and unusual punishment, and double jeopardy, as well as the rights to an attorney, due process, a speedy and public trial, and to confront witnesses at trial. If you're familiar with these amendments to the US Constitution, you may be wondering, where's the part about jury trials? This is the biggest difference between American and Japanese criminal justice. There is no right to trial by jury in Japan, meaning that the judge always gets to decide the defendant's guilt. Although since 2009, this is not always the case, which I will cover later. Having no jury basically changes everything about a trial. Swaying a jury is a whole different ballgame compared to presenting a case before a judge. Many practical strategies and tactics that are used to win a jury trial are mostly ineffective in a bench trial. For example, think of the O.J. Simpson murder case, and Johnny Cochran's unorthodox and iconic defense, highlighted by the "if the glove doesn't fit, you must acquit." Of course, there's also South Park's parody Chewbacca defense. Regardless, Cochran's tactics and strategy successfully swayed the jury away from convicting O.J. Simpson of murder. Now, imagine Johnny Cochran attempting the same thing to convince the judge from Phoenix Wright to rule in his client's favor. Would the judge be impressed and rule in favor of Cochran's client? You can decide. The other difference regarding juries is that under the Fifth Amendment, suspects charged of capital offenses and serious felonies must be indicted by a grand jury. Federal courts require a grand jury indictment in any felony, while states have various rules on grand juries. Japan has no such system. Prosecutors indict suspects in all cases. But Japan has a check and balance for this. There are committees for the inquest of prosecution, which consist of randomly selected citizens, like a jury. They review the prosecutor's decision to proceed with prosecution. In addition to no jury trials whatsoever before 2009, there are a few other major differences from American criminal justice, namely in the pre-trial phase. In Japan, lawyers are not allowed to be present with a suspect during interrogation. In the US, not only are lawyers allowed at questioning, but police must suspend all questioning if a suspect asks for an attorney. The policy in Japan has been reconsidered recently, but ultimately has been unchanged. The justification is that a lawyer being present undermines the interrogation's function. On top of that, some experts warn that allowing lawyers to be present could be unpopular with the Japanese people and crime victims because they demand the truth to be discovered. While people in the West, especially the US, can view suspects with a presumption of guilt, I believe the Japanese attitude of presuming guilt owes to the country's long history of resolutely dealing with wrongdoers. Defendants' rights were not a concern until the late 1800s with the Meiji Restoration. The Japanese did not have whole generations that were raised with the Western Enlightenment ideals of criminal defendants deserving a fair trial and having their rights respected until conviction. The Japanese instead have a greater respect for authority and are more concerned with seeking truth and justice for the victims of crime. Another difference between Japan and the US is that in Japan, a suspect can be held in jail for up to 23 days while the prosecution decides to indict the suspect. American courts have a similar but usually shorter time period of imprisonment without indictment. But on top of that, American courts have certain hearings to bridge the gap between arrest and indictment. Remember that suspects in Japanese police custody cannot see their lawyer if they are being interrogated. This means that they can be locked up away from their lawyer and loved ones for up to 23 days until a prosecutor must indict the suspect. However, on many occasions, prosecutors have extended suspects' time in jail using extra minor charges or having a judge grant extensions. In a few instances, suspects have been held in custody without being charged for over a year. Because of this, many critics have alleged that this violates human rights and refer to Japan as a hostage justice jurisdiction. This attitude is only furthered by the fact that there is up to a 99% conviction rate in Japan's criminal trials. The caveat to this is that this high conviction rate stands in front of a low 37% indictment rate. Prosecutors only prosecute just over 1/3 of potential defendants. This implies that Japanese prosecutors use their discretion to prosecute only the trials that they know will result in a conviction. In comparison, a 2016 Federal Justice Statistics report from the US Department of Justice states that about 46% of suspects were prosecuted in US federal courts. The rest of the potential trials were declined by federal prosecutors or thrown out by a magistrate judge. As for conviction rates, a 2019 Pew Research study revealed a 83% conviction rate among the 2% of defendants who elected to go to trial in federal court. This conviction rate is high, but doesn't compare to the almost perfect conviction rates enjoyed by Japanese prosecutors. In response to the controversy over hostage justice, Audio and video recording of suspect interrogations is now mandatory for certain serious crimes. The idea is to ward off forced confessions, which are inadmissible under the Japanese constitution. However, suspects can still be denied from seeing a lawyer during their time in jail between arrest and indictment. Speaking of reforms, let's talk about the one with juries. In 2009, Japan introduced the Saiban-In system, a jury system of sorts. Serious criminal cases are now tried by a panel of 3 professional judges and 6 lay judges. You may be asking, what are lay judges? While jurors simply watch and hear a trial and then decide on the defendant's guilt at the end of the trial, lay judges take a more active role in the trial along with the professional judges and even decide on the verdict and sentencing in conjunction with the professional judges. Interestingly, much like Japan's pre-World War II criminal justice system, the Saiban-In system is based off of Germany and its lay judge system, which has origins dating back to the post-Napoleonic German Confederation of the mid-19th century. Germany used to have 6 lay judges on a case like Japan does now, but it reduced the number to 2 lay judges since 1974. Despite these and other recent updates to Japan's criminal justice system, many foreign commentators and Japanese legal professionals believe that the issues behind the hostage justice issue remain unaddressed. To wrap everything up, Japan's unique criminal justice system is the way it is thanks to Japanese culture, a prolonged era of feudal justice, rapid transformation into a modern system with continental European influence, and finally the injection of American legal values. While there have been recent changes and reforms, certain criticisms still persist. Thank you so much for watching this video. If you want to see more content like this, please like this video, comment, and subscribe. See you next time.